Alaska Supreme Court case could reshape who may provide abortion care.
In Juneau, the Alaska Supreme Court heard arguments in a case that could decide who is allowed to provide abortion care statewide, testing a law that limits the procedure to licensed physicians. The outcome could ripple far beyond Alaska's vast rural map, affecting access models across the country as states grapple with provider shortages. At issue, whether advanced practice clinicians, nurse practitioners, physician assistants, certified nurse midwives can legally perform certain abortion services, particularly medication abortion. A lower court order has allowed APCs to provide care pending litigation, which, according to providers, expanded weekly availability in Anchorage and Fairbanks. The state argues physician-only rules protect safety. Opponents say the limits reduce access without improving outcomes.
Why does this matter beyond Alaska? Because scope of practice precedent in a frontier state often informs rural access elsewhere. If APCs are permitted here under constitutional reasoning, watch similar moves in other states.
Uphold physician only. Clinics must staff MDs for abortion care, tightening capacity, especially outside major cities. Permit APCs for medication abortion, stabilizes access where MDs are scarce, training and protocols become the focus. Broader APC greenlight. A wider ruling could normalize APC participation with defined training and oversight, potentially lowering wait times and travel burdens. In a state where communities can be a flight away, forcing MD-only care can turn a time-sensitive health decision into a logistical marathon: childcare, time off work, weather windows. Pro-access advocates say APCs already deliver primary, prenatal, and emergency care. The question is legal authority, not skill scarcity. The state counters that legislatures set standards for a reason, and that courts should defer to safety regulation.
What changes on Monday if APCs lose? Appointment slots collapse. Patients travel further, later, and into worse weather. Continuity of care suffers.
Decision timing from the Alaska Supreme Court and any stay orders during appeals. Whether national groups file amicus briefs tying scope of practice to constitutional access. Clinic contingency plans if physician-only rules snap back. Telemedicine, out-of-state referrals, and charitable flight networks. Bottom line, this is a scope and access case with national resonance. In a state defined by distance, the court's ruling will decide whether qualified APCs remain part of abortion care, or whether Alaska's geography becomes another barrier to timely care.